Afternoon, everyone. My name is Craig Staudenmaier. I'm an attorney here at the firm of Nauman Smith, Schisler and Hall. Welcome. I'm glad you all could make it. What could be more exciting on a Wednesday than to talk about the right to know law? This is a continuing series of free webinars that our firm has been giving this year in honor of our 150th anniversary. So we're glad you could join us today. And contrary to popular belief, I have not been here for those 150 years. We're going to talk about several right to know issues this afternoon. We have a great panel, which I'll introduce in a moment. But before I get to that, a couple of housekeeping matters. As you heard, the session is being recorded. After it's over, everyone will be emailed a link to be able to pick up the recording if you didn't get enough of it the first time. You're welcome to keep your video on or off. Those of you who are in sweatpants and pajamas, don't panic, you can keep your video off. We do ask, though, however, that during the presentations you keep yourself muted. We welcome questions. That's the purpose of the seminar. And in my opinion, any seminar is not for the presenters just to drone on about things you don't care about, to answer your questions. So please, if you have questions, and I think we already have a couple already, please put those into the chat function. And one of my jobs here is to sort of go through them, and I'll try to get to as many of them as we can. And if for some reason we don't get to them during the course of the presentation, we'll follow up with you afterwards. And as I mentioned earlier, you will receive a link to today's recording along with contact information for the panelists and their organizations within the week. So with that, I'd like to introduce our esteemed panel this afternoon. First of all, my partner, Josh Bonn, who's a partner here at Nauman Smith, Schisler and Hall, and works in the right to know area on both the agency and requester side. And along with him, we have Scott Coburn, who is the education director and in-house counsel for the Pennsylvania State Association of Township Supervisors, affectionately known as PSATs. And as I always say, in my opinion, one of the best organizations in the Commonwealth on educating its members on various issues, including right to know. And finally, certainly last but not least, we have Liz Wagenseller, who is the executive director of the Pennsylvania Office of Open Records. Liz comes with a lot of experience in state government and came to the OOR, I believe, in January. So who wants to start in the middle of a pandemic? Liz did. So I'm sure she'll have some interesting perspectives to give you on that, as well as some questions that may arise from that. So with that, we'll get started. I'll turn it over to Josh.
Good morning, everyone. Thank you for tuning in for our webinar today. I'm going to start with the very basics. First of all, what is the right to know law? The right to know law provides for the means to access public records from Pennsylvania state and local government agencies. So if you would like a public record, the right to know law provides that you can file a request with one of those agencies. Those agencies have to respond. They can either give you the record or not give you the record. If they don't give you the record, the right to know law provides for an appeals process where you can appeal a denial to the Pennsylvania Office of Open Records. And depending on what the Office of Open Records does, that can be further adjudicated in the Pennsylvania courts. So what type of records do people use, or do people use the right to know law to obtain? I have some examples here. Let's say that you want to know how much money your school district is going to spend to build the new athletic facility, a new football stadium, let's say. You can file right to know requests to find that information. Let's say you're a government contractor and you lost out, you filed a bid to build the athletic facility and you lost, someone else got the bid. You can use the right to know law to find the winning bid and how they qualified for that contract, and you could possibly use that information in the future to put in a stronger bid on other projects. If you're a local citizen or a newspaper reporter, you have a land development plan or development that's being built near your home, you can file a right to know law request with your local township to look at the plans filed by the developer to see what type of buildings are going to go in and whether those the things that are being built are compliant with local land development and zoning codes. You can use the right to know law to find out what companies were granted permits to grow and sell medical marijuana in Pennsylvania. So a lot of people don't off the top of their heads know what the right to know law is or why it's important, but I hope that some of those examples show you that it really has some practical applications for government transparency. Under the right to know law, any record that documents a government activity is presumed to be a public record unless the agency proves that the record is exempt or privileged. So for example, you cannot get a list of the social security numbers of the school teachers that work at your local school district. That's considered personal identification information. And so if you received a list of teachers from your local school district, the school district would have to redact out that type of information, social security numbers, dates of birth, other types of personal identification information. That's an example of an exemption from public disclosure. And then finally, the right to know law creates these procedures for public access. You are allowed to make verbal right to know law requests. You're also allowed to just ask an agency to provide records. You don't have to go through the formality of filing a right to know law request. Nothing prevents you from opening a dialogue with your local municipality and asking for things and not going through the right to know law to get those records. But if there's any type of dispute, in order to preserve your rights to obtain public records, you would need to file a written request. And then if that request is denied, then you can appeal that, that denial to the Office of Open Records. Agencies are supposed to respond to public records requests within 5 business days. They do have an option to invoke a 30-day extension for various reasons. We're going to talk about that later in the seminar. If you file a right to know law request and the agency responds and you're not satisfied with the response, you have 15 business days to file an appeal with the Office of Open Records. And then the Office of Open Records has 30 calendar days to decide your appeal. So that's a general overview of the right to know law. I'm going to turn it over to Scott Coburn to talk about some of the issues that agencies deal with when responding to right to know law requests.
Thanks, Josh. And thanks to Craig and Josh and Nauman Smith for having me this morning or this afternoon. Just a little bit of background for those who might not be familiar with PSATs. We represent about 1,450 townships of the second class around the Commonwealth. I appreciate Craig's comments about our educational efforts. I would be remiss if I did not thank Craig and Josh for their assistance with those educational efforts, and then also Liz and her colleagues at the Office of Open Records. Liz did a fantastic column in our October Township News magazine about busting some myths relating to the right to know law. So here we are, the right to know law, whether we love the right to know law, whether we don't like the right to know law, it is here to stay. I know that there's conversations about all the time about making tweaks to the right to know law or changes, and we'll talk about some of that later. But before I get into things, let me just say this. If you have any responsibility within your agencies for complying with the right to know law, thank you. Thank you for what you do. Thank you for sifting through reams of documents and old dusty warehouses or combing through hundreds or thousands of emails. Thanks for putting together the responses, and thanks for getting the information that our public and our businesses and whatnot are looking for. A couple of thoughts that come to mind for me. One of the things that we often hear from our members is we support the right to know law, we support government transparency, We just wish it was a little easier to navigate. I don't know how many people in this webinar today know off the top of their head that the citation for an internal predecisional deliberations is section, let me see if I can even get it right, section 708B10 little I capital A, right? There's a lot of nuances in the right to know law, which makes it sometimes challenging. But from a philosophical standpoint, are your office, your open records officers and your agencies, your governing bodies or your department heads, whatever the case may be, are they on the same page regarding how you're going to handle requests and responses under the right to know law? Are you generally going to be collaborative? Josh just mentioned, having a dialogue with requesters, having that relationship, or just handing documents out as opposed to waiting for right to know requests. Or is it going to be a little bit more adversarial? Are you going to enforce the exemptions under the right to know law to the fullest extent possible? Are you going to require that all of the requests be made in writing versus just handing them out? Both of those are certainly fine. That's the prerogative of your agency on how collaborative or adversarial you wish to be. But these are conversations that you should be having and you should continue to have, especially since people come and go within agencies, just to make sure everybody is on the same page and remains on the same page. A couple things before we get into all the things that you all want to talk about today, just some ideas for things that you all can do as an agency to make your lives a little bit easier. And hopefully some of you have already done this, but do you have policies in place for collecting documents? Who are you going to reach out to within the agency? Do they know what they are supposed to be doing when they are pulling records? Who's going to be responsible for reviewing those documents for exemptions and privileges? And you can see from the screen there, I note the Uniontown newspaper's decision. The Supreme Court of Pennsylvania has put a lot of the onus back on the open records officers to handle that. What are your policies and procedures for addressing appeals? And is your solicitor looped in with that sort of thing? So these are all things that you should have in place so that whether your open records officer has been there for a month or 10 years, everybody knows exactly what the process is going to be for your agency. Moving forward, a couple of other things that you can do to make your lives easier. Do you have websites? Are you using those websites to the fullest extent possible? Are you putting records up that are commonly requested so that you can just point people to your websites? As you put more on your website, your requests are generally going to go down. Other things to think about with respect to your website would be, when was the last time you looked at what's on the website? Have you made changes? Are you just adding documents time and time again, but not pulling old documents off, which makes it a little more challenging for people to find what they're looking for? Have you made changes as a result of COVID in your agency's operating procedures that should be reflected on your website? And do you have all of the information that you need to have on your website that is required under the right to know law? Liz in the Office of Open Records put together a really nice report recently that talks about the must-haves and the should-haves on your websites. So these are all things to take into account. Others, your solicitors. I know that agencies don't like to spend money where they don't need to. I'm certainly an advocate for that, but it may make sense for you to work with your solicitors and create template response letters, whether those are responses or denials for some of the more common denial type things, so that you can just plug in the specifics, but at the same time, I've got everything I need to from a template perspective that needs to be in those letters. Dedicated emails for right to know matters. I'm always a fan not of the personalized Coburn@psats.org, but open records requests at psats.org. Make it easier on yourself. If somebody's not in the office, somebody's going to be away, that somebody else can start tackling the process. Scanning and redactions. This is, a huge issue around the state with agencies, and we'll talk a little bit about that later. So on the requester side, and Josh sort of touched on this a little bit already, for the requesters out there participating, what can you do to help smooth the process? We recognize that you getting the documents that you want in as quick a manner as possible is super important to you. But just keep in mind that your agencies may have certain limitations, whether it's an open records officer who wears a lot of different hats within the entity, or whether it's a large agency that has some challenges just navigating the internal bureaucracy within that agency to get you the records that you need. So if it's possible, does it make sense to reach out to the open records officer first? Hey, here's what I'm looking for. Is this a record that you have? If it is something you have, how should I frame my request so that I get what I need and you get what you need, which is prompt and efficient finding those records and getting them out to you. It won't be, all of these things, both from the agency side and from the requester side, will make your lives easier, and then also the lives of the open records officers gang. And with that, I'll turn things over to Liz.
Thanks, Scott. And thank you to Nauman Smith for having us. I think this is a great opportunity to talk about a lot of important issues. And I'm appreciative that the Office of Open Records was asked to participate. All right, so the Office of Open Records. We are a independent quasi-judicial agency that hears the appeals. If a right to know request is denied, an individual may appeal to our office. And this is a big change from that was made in 2008. Before, if an individual was denied a record request, they had to go straight to the courts, which can be expensive, timely, and very intimidating for the average citizen. But the 2008 Right to Know Act legislation changed all of that. And now if you want to appeal your decision, there's just a simple form to fill out, which is on our website. You don't need an attorney. It takes about 10, 15 minutes to fill out. You don't need to be well-versed in any laws. It's just a simple form to fill out, and then it's sent to our office. So you don't need an attorney. You don't need any money. It's free. It stands out as a unique in other states where that can be much more challenging. So once we get an appeal request in, we sign an appeal officer to oversee the case. That's one of our attorneys. And during the 30-day process in which we hear evidence from both sides and arguments, then we make a decision, a final determination. And the burden of proof is on the agency seeking to deny access to prove why the individual should not have access. So once we hear both sides, we issue a final determination, which is legally binding and determines if a request is granted, it is denied, or a combination of both. If there are multiple records being requested, some may be granted and some may be denied. I thought it'd be helpful, illuminating, to go through one example of a right to know law request that went through a couple appeals process. This was the York Dispatch, a reporter, versus North York Borough. There had been some concern that a fire company was having potentially some fraud going on, and the reporter knew that the borough, not the fire company, had commissioned an audit, a forensic audit report, commissioned by North York Borough. So this reporter sent this request on January 20th. The next day, very quickly, the borough denied the request, stating that the audit is exempt as related to criminal and non-criminal investigations. There are 30 exemptions in the right to know law, and two that are often used are that records related to a criminal and non-criminal investigation are not subject to the right to know law in perpetuity. So that was their defense. Very quickly after that, the reporter sent that appeal form to our office, asking us, basically saying she thinks that the record was improperly denied. We got an extension on that one, it looks like, but a few months later, we issued a final determination granting the record. So we overturned the agency's decision denying access to that record. And the basis of that was saying that an audit is a financial record, which is clearly subject to the right to know law, regardless of what the intent for conducting the audit. So the intent of conducting the audit was for a criminal investigation. It's still an audit, it's still a financial record, and the right to know law has in court cases has said financial records are much more subject than other records. So we granted the request. That was in April. Immediately after that, the borough decided to appeal to the Common Pleas Court. So they still felt that this record, access should be denied to the record. So it went to the court, and by August, the court order affirmed our office and said, yes, these records are subject to public release, and the records were released. So it took from January to August, 8 months to get the record released, but it eventually did happen. I mean, we'll note that the reporter did a follow-up and found out that the borough spent about $8,000 on this request in terms of the court cases. So that just shows a little bit that it is can be a costly process if it goes beyond our office. So that is just one example of how the different appeals can work. All right, so a little bit more about our office. As I mentioned, it was created by the RighttoKnow Law, independent and quasi-judicial. We provide training on the RighttoKnow Law regularly. We have Wednesday morning weekly webinars on rotating number of subjects, and also the Sunshine Act we provide training on, which is the open meetings law. We had 2,764 appeals reviewed last year, which was a record-breaking year. As you all may be feeling, where you in your jobs, whether it be you are in the requester or the agency side, there's a lot more interest in public records. We only see about 3% of RighttoKnow Law requests we estimate are appealed. So that just a little bit, we had a huge explosion last year, and we expect to overcome that number this year. And we have 22 people on staff in our little office. And to get a little sense of the growth in our decisions, we had a 43% growth in decisions over 4 years. This is fiscal year, so it's a little different than the numbers I showed you before, but tremendous growth, and that number is going to keep going up. And if we had a line for our state appropriation, it would not be going up. So we are finding ways to work with what we have and continue to meet our statutory obligations in that tight 30-day timeline. Another thing interesting about where our appeals come from, the media kind of gets a lot of the highlights because of their have the bully pulpit to talk about a lot of the RighttoKnow decisions that they use for the reporting. But most, a plurality, 43% actually come from citizens. About a little over a third come from companies, 11% from inmates, and then just 5% from the media. And then lawmakers and government officials, we've seen an increase. The lawmakers had never made the pie chart before, but they did in this past year, in 2020, due to a lot of issues related to COVID and related to the election. We saw an increase in lawmakers submitting their own RighttoKnow requests. And I will pause there and turn it back over to Craig.
You're muted.
Sorry, I probably sounded better muted. I said that thank you guys it was a good overview of the process. And as I said when we began, please submit your questions, because otherwise I'm going to ask all the questions I have. We could be here till 2 o'clock. So you don't want that. One of the questions, and sort of the elephant in the room for everybody, I'm going to ask everybody sort of just to weigh in a little bit on this, then we'll get to some of the questions. COVID, it began, so to speak, back in February, March of last year. We went through a series of lockdowns and executive orders and et cetera. A lot of municipalities in particular were, claiming that they could not or would not react under the law in the normal span of things. The OR put out some regs. Just give me sort of the three of you a 2-minute version of where you think we are in terms of the COVID, what it allows the agency or requester to do or not do when they're not in normal times, if there is such thing. Josh, why don't you start?
Well, from a requester perspective, I think requesters do need to be sensitive of legitimate staffing issues presented by COVID. At the same time, agencies are required to respond within the same time frame now that they were before COVID. That was a decision by the Office of Open Records. They've issued some guidance. Whenever the state was in the red phase and the yellow phase, there was some leniency in how much time agencies could respond, but now agencies are supposed to respond within the either initial 5-day period, or if they invoke an extension within that 30-day period. But requesters can, again, you need to be sensitive. If you're working with a tiny township and someone's only working 2 days a week, it may take them time to sift through 2,000 pages of records. So we do recommend that you try to take that into account as a requester and try to work with the agency, because ultimately litigating either in front of the Office of Open Records or in front of the courts, it's not only can be expensive, but also can create a burden for both the requester and the agency. So anytime you can work something out, that's what we recommend.
Yes, Scott, do you want to go next? And Scott, if you would, I know a lot of municipalities and state agencies were invoking a statute, and the exact provision, it's in Title 35, I think, that said allow them to suspend responding on an emergency situation.
Yeah, that's maybe a webinar for an entirely separate webinar, right? Or a day's worth of webinar in terms of how much agencies and municipalities could go, or how far they could go under their emergency authorizations. But in terms of the right to know, I think Josh is right. We definitely saw around the state an uptick in agencies invoking the 30-day extension because they did have bona fide staffing limitations. People were quarantining, people were sick, whatever the case may be. The important thing there is folks have to remember that there is a finite list of categories for which you can invoke the 30-day extension. We are busy is not enough, unfortunately, to invoke that. But if people were out, COVID, sick, whatever the case may be, that could probably work. Just as an aside, you mentioned COVID. We're hearing from a lot of our members, all of the municipalities around the state have received funding through the American Rescue Plan Act. And one of the things some of them are considering in terms of responding to COVID is making investments in digitizing records so that people can access them remotely, whether they're employees or residents. So I'm curious to see where things go with that, because I think that's a good thing. Ultimately, it makes operations much more efficient for everybody.
Liz, I know your office had some regs they put out, or some suggested procedures.
Yeah, so during the initial shutdown, we put stays on all the appeals because we wanted both sides to have a chance to make their arguments. But as things open more up, now it is business as usual. It is offices are open, people are working. Absent someone perhaps being sick or having to quarantine, there should be no difference between now and regular operations. With that noted, I would ask any agencies on this to just make sure that their websites and the auto replies to right to know requests are updated. We did a review of web pages, as Scott mentioned, and we saw a lot of very outdated information saying the school district is closed and we're not taking any right to know requests. And as soon as we notified agencies, they did change that language. We did not look at all 5,000 agencies in Pennsylvania to see if the language is up to date, but just it can be very confusing, or the average citizen may be assume that you are not operating the right to know request this time. Just a reminder to make sure that language is still up to date on your websites.
And Liz, I want to stick with you for a second. We got a question was going to give you a chance to plug the OOR's mediation program. The question was, will the OOR get involved in mediating disputes, or is it purely an adjudicative?
Absolutely. We have a very successful mediation program with both sides agree to, instead of resolving the dispute about a record via submitting paper evidence, both sides can get together now virtually. You don't have to travel to Harrisburg or anywhere else. Talk out the issue, and it's in certain cases been extremely successful, because sometimes just talking over paper, just like you learn sometimes over email, things can get misconstrued. And as well, when you're talking things out, there's an opportunity to shed light on perhaps what the requester is really trying to get at. And the agency also can shed light on perhaps why that request may be challenging. So I do encourage you to request mediation if you think that having a conversation versus exchange of paper would be a better option.
Yeah, and I'll put a plug in for it too. I've been involved in a couple of them over the last year or two, and for the most part, they've been very successful. And the nice thing about it is it's very expeditious. You get a conference pretty quickly, and there really is a chance to work it out. So it is a good program, and I think a lot more people, both agencies and requesters, need to be aware of it. Scott or Josh, this is a question for whoever wants to jump in. The question is about the interaction between the right to know law and other laws that provide for access or confidentiality of records. And the example in the question was things like the Election Code or the Ethics Act. And maybe, Scott, you want to take the Ethics Act, and I'll let Josh take the Election Code.
Sure. When it comes to the Ethics Act, the big one is the statements of financial interest that all of the public officials and public employees have to generate and have in by May 1st every year. Those are not subject to the right to know law. Those are publicly available. As a matter of fact, somebody can come into the agency and request, we'd like to see everybody's statements of financial interest for the last 2 years, and they don't need to fill out a right to know request for that. That's the big one from my perspective under the Ethics Act. And Josh, I don't know if you want to give other examples of other laws that might be triggered on this.
Well, the question is the election code and voter information. Voter information is subject to its own statutory procedures for access, and it's limited what you can do with voter information when you have it. You can go to the Department of State and you can get a list of the name and home address of every single voter in the state of Pennsylvania. But when you're doing that, you have to sign an affidavit promising that you will not use that information for any non-political campaigning purposes. So you couldn't publish that information on the internet, and that's actually been challenged. I was involved in a case where a requester wanted to use voter information for different reasons. And so the requester used the right to know law rather than the election code to try to get the information. And the court, the Commonwealth Court, held that the voter information may only be accessed under the election code, and therefore that protects that voter information isn't going to be widely disseminated for approved purposes. So there are other laws out there. There's a number of laws that either make records confidential or make records public. If another law establishes the public nature or the non-public nature of a record, your remedies to get that record under the right to know law are limited, and typically those other laws trump the provisions of the right to know law. So you do, if you're requesting certain type of records like voter records, you need to keep that in mind.
And I can't help but make the observation that the Supreme Court has said that your home address is protected by a privacy provision, and yet I can go to the Department of State for $25, get the name and address of every registered voter in Pennsylvania. But that's for another seminar at some point in time. Another good question that we got is, what's the state of the law on creating a record? And the question hits sort of on it, in terms of, under the law, I think everyone knows, or if you don't, the agency is not required to create a record. And yet the courts have said that pooling information and compiling is not creation. But if you guys could give us sort of a guideline, and maybe Scott, I'll ask you from the agency standpoint, and then maybe Josh or Liz, you want to, well, let's say Josh on the requester side. I want to make Liz take a side. So, but if you have an OOR perspective, we certainly can hear it. But just, you want to go first, Scott?
Sure. From an agency perspective, this is definitely one of those issues that causes a lot of consternation, right? What where does the line, where do you cross the line between simply pulling information from an existing electronic record and when are you creating a new one? But stepping back a little bit, just the act of pulling from the electronic database is something some agencies just aren't aware of to begin with. So it is important to make that clear that if they've got, whatever their accounting software is, if they get a request that includes that information, they can save it, they can print it out, they can send it electronically, whatever the case may be. But that information, just because it's not in a typical 8.5 by 11 piece of paper, that information is still subject to a right to know request. I am not aware of sort of anything that is changing under the issue of creating records, electronic databases. I don't know if there's any relatively recent final determinations that would have an impact on that. But I think it sort of is what it is at this point.
Yes, this is Liz. Yeah, I would agree. The courts have just repeatedly said that information is subject to the right to know law. And we've consistently upheld that in our final determinations.
But a plug I would make would be, a record may have information on it that 90% of it may be public, 10% of it may be something that should be redacted. If your agency has not invested in redaction software, this is where you can save yourself a lot of time and aggravation down the road by purchasing that. A lot of them there are free services that will do that. So as you're pulling those electronic records, you just automatically black out this portion and away we go.
Josh, any from the requester standpoint at all? Anything to add?
Well, there's going to be a case decided later this year. It's scheduled for argument in the Commonwealth Court in December involving a school district and whether or not redacting information that's extracted from an Excel database constitutes the creation of a record. The Office of Open Records in the Philadelphia Court of Common Pleas held that was not creating a record, but that issue is up for appeal before the Commonwealth Court. So we're going to get more issue on that information. One other circumstance I can think of is whenever there was a case in the Commonwealth Court involving someone wanted an agency to go to two different databases, pull records from one database, pull records from another database, combine those into one spreadsheet. And the Commonwealth Court said that is creating a record. So a rule of thumb for requesters is if the information exists in one database and it can be extracted by the agency from that one database, you can access the information in the same manner that the agency can access it. But if the agency has to do any compiling or pulling from multiple sources and putting documents together, that's considered the creation of a record.
Yeah, in fact, I remember one of the early cases involved deer counts or something, and the court said that just pulling data from different places is just like going to a filing cabinet, opening the drawer and pulling it from different files. It's not creating a record, it's just gathering the information. Next, I want to combine two questions that we got involving the infamous 30-day extension under Section 902. And the first question dealt with a situation where someone filed a request and the agency asked if they could take the 30 days. Now, the question doesn't make clear whether they actually invoked it or just asked if they could take 30 days. And then the person wanted to know if they could go back and sort of say, I take backsies, I want it now. And then the second part of the question is, if an agency invokes the extension, and I love this question, do they still have an obligation to act as quickly as possible? In other words, could they produce the information in 20 days? I've never seen that happen, but so let's see, Scott, I'll start with you and then go to Liz.
Well, let me give my thoughts on the second part of that first. I think it would certainly be good practice to fulfill all requests, whether they are a typical 5 business days or a 30-day extension situation, in as timely a manner as possible, right? That's just good government. But under the right to know law, and Liz, Josh, tell me if I'm wrong here, I'm not aware of anything that would require, once it's been invoked, as long as it's been properly invoked, if they have it fulfilled within 14, 20, 29 days, whatever the case may be, they still have the 30 days to comply. So to me, it's a, it's a good government issue there.
Yeah, I would agree. You can wait till day 30. You can do it on day 6 if you'd like. And realizing that there may be some particular situations that are more vexing, to use a word I'll discuss later, it may behoove you to give it as soon as possible. Sometimes creating friction with requesters, creating animosity does not help in the long run. So I think that being efficient and getting that record out sooner the better just creates good dynamics in the relationship with that requester.
Yeah, and the only comment I would make is, and the first one will be a smart, alecky comment, and the second one will be more measured. But I had a reporter call me a couple of months ago and say, well, if I make this request, how long does the agency have to respond? And I said, well, they have 35 days. He said, well, I read the statute and it says they have to respond in 5. And I said, yeah, but they're going to ask for a 30-day extension, which they did, So, but the flip side of that is that, that agencies have limited resources a lot of times, particularly under current circumstances. I mean, whether you want to talk about COVID or, employment issues and filling holes in staffing. So a lot of times the 30-day extension is really needed. But I do think to some extent there's a knee-jerk reaction that the open records officer says, well, I'm going to put the extension out there just to give me more time because of the other 15 things I have to do in addition to being the open records officer. So when you're a requester, just sort of keep that in mind.
Yeah, and Craig, let me just, obviously I represent an organization full of open records officers, right? Agencies. When I was talking about the good government example, just so everybody's clear, if you have found the records, right, there's no sense in holding off on, at least in my view, holding them off. But to Craig's point, it may be a situation where you need the additional time because you are doing other things, right?
Okay, now, Josh, this question I'm going to put to you. It's a situation involving plans and engineering drawings for a planning meeting coming up, and someone has asked to see them ahead of the meeting. And the planning board and solicitor have not seen them yet, and they're not ready to be brought before council for approval. Is that something that person has a right of access to, or can you deny access at that point?
Well, my opinion would be that they would have the right to review those, even if they haven't been shown to the solicitor or the planning commission yet. But you could always, if you're in the agency's shoes, you could always ask the requester to file a right to know request, invoke a 30-day extension, and then probably the solicitor and the planning commission will have time to look at it during that 30-day extension. So that's a practical answer for the agency. But there's nothing that says that something is a public record is in general is secret before it's put before the government. And I do understand the purpose of the question, because in land development, you often have times that the governing body is acting in an adjudicative capacity, and it really shouldn't be reviewing the records before it's actually presented to them at a hearing. But that doesn't mean that members of the public can't review those plans and try to find issues with the plans that they want to raise at the hearing whenever it's presented to the board. It's really not fair to the public if they can't see the plans before that hearing happens.
Yeah,
Craig,
go ahead, Scott.
Craig, this may be a request that we start to see, a request type that we start to see more and more of in light of the recent changes to the Sunshine Act and the agendas, the advanced agenda notice.
Yeah, just say what that, Scott, just fill out in case people aren't aware of that. Just tell them basically what that is.
Absolutely. So there were changes that took effect in late August that require any agency subject to the Sunshine Act to post either at their agency building and at their website, on their website if they have one, an agenda. And subject to some exceptions that we don't really need to get in for purposes of here, it's going to allow members of the public, members of the media to have a better understanding of what is going to take place at those meetings.
Okay, the next question says, and the person who submitted it, if you're still on, if you could just clarify, it says, are complaints submitted to a municipality protected under any of the exemptions?
I think I know probably what they're getting at. Yes, so we get a lot of appeals about this. Someone wants to know who complained that they're to the municipality that their dog was barking or that something happened. And those are not subject to the name of the person who complained. It's considered part of a non-criminal investigation. So you won't be able to identify, who the name of the person who submitted some complaints might be. I think that's what they're going for.
Yeah, I think you're right. In fact, I remember, I think I saw one of the very first cases argued about somebody had filed a zoning complaint against somebody, an attorney, and the attorney wanted the name of the person who had filed it. And the court said, no, you can't, you don't get that under the, for those of you familiar with the law, if you look under the provisions, I think it's 16 and 17 under 708B, there's a litany of things that are specifically said you don't get. And one of them are the complaint made and background information, investigation notes, etc. So it's hard to get. I want to go back for a minute to something that you all discussed early on, and that's the use of websites and the information that is required or advisable for agencies to place on their website. And Scott or Liz, I don't know which one of you wants to address that.
Liz, do you want to take that one?
Sure. Yes. So the RighttoKnow Law does outline what you are mandated to put on your website if your agency has a website. Some do not have a website, some smaller municipalities. You must provide contact information for the open records officer. You must provide contact information for our office, the Office of Open Records, and you must provide a right to know request form. Those should be very easy things to post. The first one, you know who your open records officer is and how to get a hold of them. Our office, you can go to our website and copy and paste our contact info and a request form. We have a universally accepted request form. You can just use ours. You don't need to start from scratch and create your own form. So very easy things to do, but we did find in our review that not a strong majority have all those three, but those are legally required. And the fourth one, if you do have policies and procedures outlining how you handle right to know requests, you should post them, but you're not required to have those. So those are the things that the law says you need to have. In our review, our thought is the more information, the more accessible making these right to know requests are, the better it is all for everybody. It makes it easier for the requester, makes it for you all easier for you all, for the agencies to perhaps handle the requests and organize them. And so what things we've talked about is making it easy to find on your website. Either at the bottom of a lot of people's website, they're having address, this, right to know requests, have it at the bottom of there, or a drop down menu where about our office or more information. So having it easy to find is important. Outlining all the different steps is important too, so people understand what they need to do. And one thing that is really helpful, if you have right to know requests for the same information over and over and over again, just put that information on your website. It'll save everyone time if you do that. So those are some of the tips that I like to give people about making things easier for everyone.
And you hit on something, and Josh, I'd ask you to put your solicitor hat on for a moment. What do you think in terms of agencies and the advisability of having a right to know policy, and what should it have in it if you do have one?
Well, it should have any specific procedures that you want someone to follow when filing a right to know law request. An agency can have its own right to know form. Agencies do have to accept the standard form that's published on the Office of Open Records website, though. You can't deny a request just because someone didn't use your specific form. But you may have reasons why you want to use a specific form. You may have tracking purposes that you want to use a specific form. Let people know the name of the open records officer, what address requests should be submitted to, whether they can be submitted in person, by mail, by email. let them know all that contact information. And I'd also recommend having a telephone number available for inquiries to the open records officer, because I think agencies and requesters can save themselves a lot of time and expense if they try to work out disputes without using the OOR or the courts.
Another question we just got was, is there any legal limitation on the number of right-to-know requests that an individual can submit to the same agency within a certain time frame?
I can take this one as well, if that's all right. And I saw a question about the vexatious requester bill, so these can all go together.
What's a vexatious requester? I don't know what that term means.
Yeah, so the answer is there's no limits. However, there is some legislation that is passed in the Senate, will be addressed in the House, I think, in a couple months about that issue. And the name of the bill is the vexatious requester bill. And I've heard endless complaints about the name vexatious requester, but I didn't come up with it. So the idea behind this is if you have an individual, or more than one individual, hopefully not, who is using the right to know law to annoy an agency or to bother them, the intention is to be vexing. The way I explain it to people is a 1-year-old cannot be vexatious. They don't know that they're annoying you, but an older kid certainly can be. So the idea behind this law is if an agency believes that someone is intending to use the right to know law to annoy, they're not trying to get information they're using for a purpose, they're submitting countless requests, the agency under this legislation could appeal to our office, the Office of Open Record, and say, we think this individual is a vexatious requester. Here's our evidence as to why. Then the allegedly vexatious requester can defend himself or herself. Here's why I'm not. And then our office, like we do in our appeals, considers both sides and issues a decision, either saying, yes, they are vexatious or not. And if they are deemed vexatious, they can be denied the ability to submit any right to know request to just that agency for up to a year. So it's kind of like a timeout for a while, so that those requests will stop. So I'm never one to try to guess what the legislature is going to do, but it is something that is being considered, and we will see what happens next.
So it's like a no-fly list, okay?
Yes.
On the vexatious requester list. Some requesters may wear that as a badge of honor to some extent, who knows?
Yes, yes.
Like I said, I know it passed the Senate, correct?
Correct, yes.
I'm sorry, I did have the bill number, but I don't have it in my head at the moment.
552, SB 552.
Thank you, in case anybody wants to go on and take a look at it. Okay, the next question we got was, would a request for student face mask exemption information, including if the exemption is from a parent, medical, or religious reason, be protected? I'm going to throw that one over to Josh for the moment.
I would say on an individual basis, yes. I believe that would be personal information. And if it doesn't fall under any of the specific exemptions under the right to know law, I think that would be personal information that's protected by the constitutional right to informational privacy. However, on an aggregate basis, I don't think the same concern is there. So if I file a request with a school district asking how many students requested religious exemptions from the face mask requirement, I think the school district can release that information. Now, maybe there could be an argument made that that's somehow protected by the FERPA, which is a federal law. I can't think of what that acronym, the exact words for that acronym at the moment. There might be
Federal Educational Right of Privacy Act. Yeah,
correct. But I don't believe that information on an aggregate level, to the extent it doesn't identify an individual student, I don't believe that would be exempt. Information about individuals would be exempt. Aggregate information would not be exempt.
So individually, no mask. As a group, unmasked. Is that what you're saying?
Something like that.
Okay. Then I had another question. I think we have about 5 or 6 minutes left. Fees. I have to say that when the right to know law was first passed, I thought there was going to be a tremendous amount of litigation on the question of fees. And I've sort of been surprised, and I'm not suggesting there should be, by the way. but there has not been a lot. But Scott, if I could just have you just for a minute in terms of just to sort of review two categories of fees, if you will. Number one, whether or not an agency can charge for labor or time spent in researching, reviewing, and redacting records if needed, and then fees for copying, and when those copying fees can be required upfront and when they can't be.
Sure. As they cannot charge for their time, at least at this point, they cannot charge their time spent fulfilling requests. They can't charge for the solicitor's time helping out with responses, whatever the case may be. Sort of companion to Senate Bill 552, there is an effort in the General Assembly. There is a bill out there that would, if passed, allow agencies to recoup some costs if those are requests that are made by commercial entities. And as Liz pointed out, I think 37% of the appeals that come to the OOR are driven by commercial companies. Whether that ultimately happens or not, we shall see. But I know that has been an issue that our members have struggled with over the years. That the information is being collected and then turned around for a business purpose. We can debate the pros and cons of that, but that's where we are right now. And then on the second one, I'm having a blank here. The law was just changed to reduce the threshold to $50, right? Yeah. Okay. I get my numbers mixed up. So basically, if an agency gets a request that would involve an awful lot of records, more than $50 worth of records, say at $25 a page, or 25 cents a page. Sorry, Craig.
I know my heart skipped a beat there for a minute.
I'm sure it did. 25 cents a page, it can require prepayment from the requester before the records are provided. And we always suggest that be and I know the Open Records Office does, a simultaneous, here's our money, here's your records type thing.
And Liz, let me ask you sort of a corollary of that question. Let's assume I made a request to one of Scott's townships and they ended up spending well, let's say $70. So they couldn't, or let's say $40 now, they couldn't require prepayment. I didn't pay for those. I make a second request later on. Can they withhold answering to my second request because I still owed money from the first?
Absolutely. If you are in debt to the agency, you cannot demand records until you pay that debt.
And let's see, and I want to try to hit one other thing too. And Josh, I'm going to put this to you first. The Supreme Court in April this year, speaking of the pre-decisional deliberative exemption, which is one of my favorite things to say, and basically held that any communication with an outside consultant is not protected by the deliberative provision because it's not internal to the agency. Now, could you just address that in terms of what effect that may have on the pre-decisional deliberative process? And I guess the question becomes, what if you have a situation where the township or another municipality has hired someone to do something in an official capacity, say something like collecting taxes or doing road repair or something of that nature?
Well, ordinarily, Craig, deliberations of public policy are exempt under the exemption that you mentioned, the pre-decisional deliberation exemption. But agencies, because of that Supreme Court ruling, agencies have to be careful about who they're deliberating with, and whether the person you're deliberating that information with is an employee or an independent contractor makes a difference, because you cannot, the exemption does not shield deliberations with an independent contractor. The case in question involved communications between an engineering firm, or between a city, an engineering firm, and a law firm. For some reason, the law firm didn't argue attorney-client privilege, so that was waived. And it was just whether those communications were deliberative or not, whether they were internal to the agency. The Supreme Court held that because the engineering firm and the law firm were not employees, but were independent contractors, that exemption did not shield those communications.
Yeah, and Scott, I don't know if you want to get a 30-second plug-in of what you're advising your members, many of whom are on this conference call, how to deal with that now that, of course, the law changed in April, so it's been a while, but still in terms of records.
I think it's definitely going to be a challenge, particularly for smaller agencies that rely on the knowledge and information by third-party experts. And for the sake of full disclosure, we submitted an amicus brief in support of the agency on that one. Obviously, the agency side was on the losing end there. At this point, we haven't seen any direct repercussions, but I can see them coming. So like Josh said, we're just advising our members, you have to be aware, here's the issue, and you have to be comfortable that the records you may be exchanging with those third-party contractors may ultimately find themselves into the public domain.
And Liz, I'll give you the last word to 30 seconds from the OR perspective.
Yes, we've seen the impact of this already on a handful of final determinations. And one I would mention was there was a request for records regarding an ICE detention facility in York County. And, because of what that decision said and the fact that the internal would be a Commonwealth agency or a local agency, judicial agency or legislative agency. ICE is none of those things. So the county's use of saying internal predecisional was denied in the request to withhold those records.
All right, well, we have come to the magic hour, and I know time is precious to everybody on here. I want to take this opportunity to thank our presenters who did an excellent job in responding to being peppered with various questions. Also want to thank everyone who participated in today's seminar. We hope you found it useful. If you do have any questions still, and you want to sneak them into the chat thing, we'll hang on for a while longer, or we'll provide information to you based on your registration, how to contact myself and all the panelists that, well, if you have a particular question you want to direct towards them. So with that said, thank you, everybody. Enjoy the rest of your day and keep on doing those open record requests. Thank you very much.
Thanks, Craig.
Thank you.